Good morning, I'm Matt Weidner. It's the end of the first full week here in 2011, and I want to jump right into what's happening up in New Jersey. As most of you are aware, the New Jersey court issued an order directing many of the servicers acting in that state to provide responses and answers to questions why the court shouldn't suspend or dramatically change the foreclosure procedures in that state based on a variety of conduct that is detailed with great specificity in the administrative order that was released in December. This order went out to the foreclosure plaintiffs that were filing foreclosure cases in the state of New Jersey, and this 18-page document, which is included here, gets into some very specific facts about troubling conduct that the court found operating in the state of New Jersey. I want to encourage you to read very carefully this administrative order. I want you to pay particular attention to the specific findings and the issues that this court found with regard to the practices as being submitted in the state of New Jersey. But then I want to pay particular attention to the responses that have recently been submitted to the court. What I find most troubling about the responses by these major servicers is they seem to suggest, basically, not seem to suggest, they outright assert that the court lacks the jurisdiction or lacks the authority to impose many of the sanctions and checks that the court asserts to impose on the court. I want to read particularly from the Wells Fargo response to the court, and in it says, moreover, the directives could have other unintended negative effects on the state's economy, period, and the court can avoid the difficult legal issues raised by the OTSC and achieve its stated goals by allowing Wells Fargo to continue its process. Again, the court can avoid the difficult legal issues raised. Ladies and gentlemen, we are in a crisis in this country. Our courts are in a crisis right now because there have been very difficult legal issues raised by what's happening in foreclosure courtrooms. And we cannot, as this document suggests, avoid those difficult legal issues. We must confront those difficult legal issues head on. The thing that is troubling about all of the responses that have been submitted so far is they, in my opinion, gloss over the significant and substantive issues that are raised by this foreclosure process and the scandals, and they get right into the fact that we want to clean up our act and we want to move forward. We can't do that, folks. We have to look backwards at what occurred in the midst of this crisis and how it was allowed to occur. We cannot, as is being suggested both in these proceedings and in a limited way in the 50 state attorney general proceedings, just move on along this with no substantive examination of exactly what occurred. In this state of Florida, we have bizarre documents being filed in court, motions to ratify judgments. The attorneys in many of these cases have admitted that there were wrongdoing in relation to the documents that were submitted in cases. And in this motion to ratify judgments, they're asking the court to ratify judgments based on some new affidavits. The fundamental problem that I have with that is how can you ratify a judgment when you have no idea what the real problems were with those prior affidavits? The fact of the matter is that we don't have any idea what was wrong with those affidavits. We have vague assertions in the motions to withdraw the affidavits about what went wrong with the process, but we don't know specifically what was wrong. There are no depositions. There are no affidavits. There are no evidentiary hearings from those attorneys, from those law firms, from those affiants or deponents in those cases, which describe specifically what was wrong with the affidavits and why they sought to have them withdrawn. And frankly, until we know the answers to those questions in a very specific way, we cannot move forward. We should not move forward with those judgments and with those foreclosure cases. The fact of the matter is that we are all entitled to due process in this whole examination. We cannot just sweep this under the rug. We cannot allow our attorneys general to just move past this and not engage in a proper and detailed judicial and regulatory examination of what went wrong. These are difficult times out there, people. This war is a hard one, and it's one that, unfortunately, at this point in time, the consumers are really getting the bad end of the stick. We need to continue to keep the pressure up. Our press is doing a very good job of covering all of this. There are dedicated activists out there, attorneys and pro se defendants that are carrying the ball for all of us. I think most of America is starting to recognize now that what's happening in foreclosure courtrooms is not just the business of people in foreclosure. This is important to all of America because fundamental rights are at stake here. And if we don't stop them now, if we don't stop this mad rush towards throwing rules and statutes and procedures out the window, then nothing's to stop them from trampling on the rest of our basic civil rights. Keep up the fight. Keep information coming, and